ಸರ್ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರಾ?
ಬಾಬು ಕೂಡ ಸರ್ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ ಸರ್.
Yes, ma'am.
ನಮಸ್ತೆ ಸರ್.
Namaskaram, sir. Namaskar, sir.
ನಮಸ್ತೆ. Right.
Bona madam, shall I start?
Hey, wait.
Okay, sir.
For another 2 minutes.
Another 2 minutes are there. Yeah. Sir, yeah.
Okay, sir. Okay, sir.
Baba Goda sir, namaste.
Namaskar, Vijay. How are you?
Hey, fine, sir. Fine. It was very good that you are a research person for this. We are going to be benefited by your.
Thank you.
Your valuable
Hopefully.
speech, sir. Yes, sir. Yes, sir.
Hopefully.
Thank you, sir. Thank you so much.
Thank you.
బాబు సార్.
Yeah. Oh.
Bhuvaneshwari sir. Good evening, sir.
Good evening. Good evening.
Nice to see you, sir. Most welcome to the FDP, sir. We are
Thank you.
eagerly waiting for your session.
Thank you. Don't put pressure on me.
Oh, we are not putting the pressure on you. It's a pleasure listening to you, sir. Vijay, sir, shall we start?
Just one more minute is there.
One more.
One more minute is there.
Babu, good evening.
Good evening, sir.
Subhash is
here.
here.
Subhash.
Yeah.
Arre baap re. After so long.
Yes, sir. How are you?
I am very fine. How are you?
Fine. Now at Kerala.
Good. I agreed for this program. At least I could meet my old friends.
Yeah.
So
Okay.
how are you?
Bye. I'm fine, sir. Doing
Yeah.
good. Okay. Contact later.
But why you are joined? You are LLM in labor law.
Yeah. But the new labor code, you know.
Yeah.
Okay, Vijay.
Okay, sir. We'll
Yeah.
meet you
Please
later.
start. Yeah.
Yes.
Good evening, all of you. Over to Vijay. Vijay, start the session.
Yes, sir. Yes, sir.
Gonna start recording the proceedings now.
Yes, sir. Yes, sir. It's already recording, sir.
Right.
Everything is.
Right.
Good evening,
Yes,
everyone. Good evening, everyone. Respected research persons of the day, Dr. Vivekananda Patil, sir. Respected Principal Dr. K.B. Kempegowda, sir. My esteemed colleagues and dear participants. I am Dr. Vijay, an Assistant Professor and Coordinator Faculty Development Program. It is my privilege to welcome the Day 5 of 7-day Faculty Development Program on New Labor Codes. It is my honor to present a brief profile of our esteemed resource person. Dr. Babu Goda Patil, he has been a part of EM Salalgarh College of Law from last two and a half decades. Presently, he is working as an associate professor. He obtained his requisite qualification from Karnataka University, Dharwad. During his post-graduation, he specialized in labor law. After teaching labor law along with other subjects, he chose human rights of disabled person as his preferred choice for his Doctor of Philosophy. He submitted his work for award of PhD and was later awarded the same for his thesis bearing name Right to Education and Employment of Person with Disability in the year 2012. He was associated with various programs organized in state of Goa relating to same. Later, he worked on the connected area of mediation and negotiation. He was instrumental in developing a computation on negotiation and making VM Salalgarh College of Law as one of the pioneer in ADRS skill teaching. Along with the senior colleagues, he developed a model for teaching skill of client counseling, teaching skill of negotiation and mediation. He also runs a certificate course in conflict management for students from various disciplines. He is a visiting lecturer for the LLM program on human rights and ADR certificate program at Shivaji University, Kolhapur, Maharashtra. He has been encamped as a resource person in the Karnataka Institute for a Law and Parliamentary Reforms, that is Kilpar, Bangalore, a government of Karnataka initiatives. He has been a part of the UGC initiative of Patashala. He worked on access to justice and recorded 4 live lectures for the benefit of students. The lecture is available at UGC website. He is a part of the National Organizing Committee for Louis M. Brown and Motion Client Counseling Competition. Presently, he is a national consultant to Vivekananda, a social enterprise from Bangalore, working in the area of right of senior citizens. He is a member of Board of Studies of Dayananda Sagar University, Bangalore. He contributed to the law and process of adoption by being an advisory member to the CARA under the Women and Child Department, Government of India. Working for the implementation of national education policy as a director of the internal quality assurance cell of the institution. He is chosen as a member for social impact assessment unit by the state of Goa under the Land Acquisition Act 2013. He has published 40 articles to his credit along with many paper presentation at prestigious national and international seminar. He has authored a book titled In Search of Courtroom Ethics, published by Oakbridge, a publication house from Delhi. He has visited institutions in Madhya Pradesh, Gujarat, Delhi, Kerala, Karnataka, Maharashtra as a resource person in faculty development program. With this brief introduction, sir has accepted our invitation and agreed to deliver a lecture on collective bargaining under India's new labor codes, key changes and emerging challenges. I, on behalf of the Janata Education Society, Vivekananda College of Law, and on behalf of my colleagues and dear participant, a warm welcome to you, sir. And also
Thank
I welcome our beloved principal, Dr. K.B. Kempagowda, sir, on this occasion. And also I welcome my dear colleagues and dear participants on this occasion. Over to you, sir.
Thank you very much. I will share my slides first and then I'll. So is my slides are visible, sir?
Yes, sir. Yes, sir.
Yes, sir.
Thank you. At the outset, I thank Dr. Kempagowda for inviting me for this FDP program. Jeet Mansingh onwards, there are legal luminaries are part of this, and I am very happy that I have been put up along with them, Sandeep and others. It's an honor for me to be part of this FDP. At the same time, I thank Vijay for being in touch with me all the time. Bhuneshwari is my college mate. When I was doing LLM, she had joined LLB. So I thank her also because a long time back we had met, and that time we had discussed that we will have something together. But finally, it is materializing now. So thank you very much for all the love that you showered on me. So my discussion today is on collective bargaining under the new labor code. Why dialogue is a necessity is one part of my discussion. Actually, when I was preparing for this lecture, my thought process was very different from what was when I quoted this topic or when I requested organizer to allot me this topic. Because when I started preparing for this, I realized that things are not same as it was. When we studied labor law, when we did research on the labor law, collective bargaining was an entirely different ballgame. Now things have changed so much that there is a need to rework on the concept of collective bargaining. So therefore, what I have done I have exercised a little bit of liberty by myself. And what I have done is I have divided my whole discussion into 7 different discussions. So I call it as a different areas of discussions. So where I'll be trying to talk about various things which are connected with the collective bargaining. So I would be talking about the labor code, the present labor code, how the labor code is beneficial to labor workmen, not beneficial to workmen. These are all opinions that I'm expressing. And if anybody has any queries, counter opinion, debating with my opinion, you please feel free to put it on the chat box. And I request Vijay to keep the chat box open so that you can stop me and we can discuss that point at that point itself. But anyway, I'm going to keep some time for question answers at the end. That can also, you can raise those issues at that time also. Preferably, you can stop me and we can continue our discussion at the later stage. And I have seen many of you are traveling and not at one place. But I suggest that you relax at one place because You listen carefully. There are questions I am going to raise, and I want you to answer it in your chat box, and what you feel about, what you think, what is your answers are all about. Because after every discussion, I prefer to talk to you about your opinion on that topic. Then I'll move on to the parties involved in the collective bargaining. Now, when I say parties involved in the collective bargaining, please understand one thing. When we talk about bargaining is everything about necessities. So if I am under dire necessity to have it, then I have a very low bargaining power because I can't survive without that. And the other person is in a stronger bargaining. Similarly, if I am the only seller in the town, my bargaining power is more because they have no other option but to buy from me. But if there is only one buyer and the multiple sellers are there, other person is in a position of strength. So when we talk about collective bargaining, it's all about the show of strength. So we need to understand the parties involved in the collective bargaining and the strategies that they use, because in a collective bargaining, you need to improve your bargaining power. And all the time you should work towards improving your bargaining power. And then only you can do well in a collective bargaining process. And we will spend some time in how the strategies are used to it, and then how those strategies have resulted into some of the greatest achievements in the history of labor law jurisprudence. Few of them we are going to discuss that also. Then there are mechanisms invented by Labor Code, even Industrial Disputes Act, which actually imitates the collective bargaining, which imitates the trade unions. So those mechanisms also we are going to check. So then we end our discussion with how the collective bargaining at presently working, whether it is successful, whether it is having the same euphoria which it had earlier, or its importance are going down. That's what we are going to see in our next 1 hour or 1.5 hours time. So let me start with the first discussion. The first discussion I'm taking up is coverage by the labor code. Now, this is an important point that you need to understand, that the labor code, what has been passed recently, they have reduced the area of coverage. 82% of workers are from informal sector. So for them, implementing labor law is a difficult task. Remaining 18%, out of that, 14% are working in micro, small, medium industries. When we talk about micro, small, and medium industries, they fall out of labor code, because according to Industrial Relations Labor Code, most of the provisions are applicable for an industry with more than 300 workers. And now the remaining 4% are governed by this Industrial Relations Code. Why? What was the reason that they went from 100 to 300? Why there is a change in this approach by the parliamentarians, by the legislatures? Why they reduced the coverage of labor code to brought it down to only 4%? These are all the questions which just bombarded me and went on researching. I found few of the things which I want to share with you. Why the support, legal principle that support the increase of the threshold. First is a doctrine of reasonable classification. So when I was working on this, many researchers, legal luminaries argued that there is a classification between medium industries and big industries. And this classification is valid. Even if it is challenged in the court, this classification will survive, because it follows a doctrine of reasonable classification. Secondly, proportionality and balancing of rights. Many of the researchers argue that the moment you apply labor code, the moment you apply the rights of the workman to an industry, cost of production goes up. The cost of what do you call it as complying with the requirements of the law, it is going to suffocate. It's going to make the industry suffocated to death. So by increasing the threshold, we have saved the industry. That is a proportionality and balancing of rights, because we need to balance between industry's right to conduct profession, carry on the profession, carry on the vocation, carry on the manufacture, and labor rights to livelihood, etc. So that balancing of rights, there was a necessity, and that's why they increased the threshold. Now, this is another interesting argument. They are saying when industry came into existence in the early 19th century, so that time the whole industrial jurisprudence was absent. Nothing was there. So therefore, everything was managed by the market. Demand supply was working on it. So the people were made to work 16 hours, 18 hours a day. There were no labor rights. There was no unionization. It was a pathetic condition. And also, for the first time in the civilization of the human beings, there was a migration. Earlier, the migration was for in search of food. Now, the migration is for in search of work. And this kind of migration was never heard of in the human history. Then there was a creation of slums, creation of cities. All these came into existence, and that put a pressure on development of law. And that's why migrant communities were vulnerable communities. So therefore, there was a law regulating the labor rights. Then from law, we went to regulation. So instead of controlling the industry, we started regulating the industry. Now we are going to contract. Now, in the contractual regime, it is basically the two parties decide what is good for them and work accordingly. So therefore, by increasing the threshold, we are leaving it open to the parties to decide what they want and what they want to do with their the right to give labor to the best of their benefit. Contractual and negotiated workplace rules, continuing with that, from as the law is taking back seat, contract is coming to the driver's seat, and the contract and negotiated workplace rules are taking over. So therefore, by increasing the threshold, we are giving more space for the contractual rules, regulated workplaces. Another policy which worked in favor of increasing of the threshold is ease of doing business and regulatory relief. Please understand, market is ruthless, especially the international market. And to survive in the international market, you need to compete at the international level. And to give a decisive advantage in the market, they have eased out the labor law, because labor law means increase in the cost of production. Then targeting protections. Now here, when you talk about targeting the targeting protections, we are talking about protecting the industries from unreasonable competitions. And that's why we are easing out all the rules and regulations. So, and finally, substantive protection remains. Many of the researchers feel nothing has changed, nothing will change. Only earlier the rights were regulated by the law, now the rights will be regulated by the contract. So no need to panic, everything will remain same, your rights are safe. That is what some of the researchers sincerely think. So this is how the things have worked out. Now let me ask you a question here. I have given you various principles, policies for your understanding of increasing the threshold to 300 under the newest labor codes. My question is, Now, workers are as vulnerable as they were in the pre-industrialization era, like I was mentioning about when for the first time there was migration in search of work, when the first time slums were created, cities were created, how vulnerable they were. Now, are we making the workers again vulnerable? So this is one question you should think about. Because when we look into those principles that we discussed, things look not bad. Especially, it doesn't look good, but it looks not bad. But is it really like that? So that's what you have to think. Second, is labor code becoming redundant? Now imagine a law which is applicable to 80% of the population of India. Can you think of any law? Please put it in your chat box. Any law that comes to your mind that covers, say, 80% of the population. Don't give me criminal law and other thing. Criminal law definitely covers 100% of the population. In the civil part, other than the procedural laws, anything comes to your mind? Yes, anyone? Most of the general laws, yes, Dr. Sumitra, I agree, but can you give me one law, one specific? Indian Contract Act, yes. Indian Contract Act covers everyone. IPR covers only the people who are inventing, no? Transfer of property, yes, good example, Dr. Vidya, it's a good example. Yes, you are stealing from me. I answered it, Indian Contract Act. Dr. Sumitra. Most important, labor laws, that's what I was mentioning now. Only 4% of the population or maybe workers are covered under the labor laws. That is why the question is, what is the scope of the labor code? It is becoming slowly redundant. Take the example of Consumer Protection Act. The Consumer Protection Act, all the people living within India are consumers. Therefore, the law is very important. Whereas labor code is applicable only to 4% of the population. Now, that's the sad part of it. So that's why when I say that we need to work on making labor law more and more relevant. Therefore, how to make it workable? Forget about law. Okay, they don't want to protect, let them know. But there are other ways of doing it. Collective bargaining is one method of doing that. So next, I'm talking about, next question is, do you agree that corporations are gaining more and more space in the legal system as compared to workers? What I mean to ask is, do you think that the corporations are becoming more stronger as compared to workers? So if you look at that, yes, if you look at the idea of, sorry, I'm going back. So this also you have to keep this question, keep the answer in your mind. Then I'll move on to the next discussion. So now I'm coming to the second discussion. Let us understand the parties. Here there are two parties who are involved in the collective bargaining. One is the employer, other one is the worker. When I say employer, I am keeping large industries in mind because labor code is applicable to people above 300. Not all, some of the important provisions are applicable to the industry with more than 300 workers. So one side is the large industries, other side is large trade unions. Let us try to understand that. Now, during my childhood and during my college life, we used to talk about MNCs, multinational companies. Soon, MNCs became TNCs, transnational companies. So that means they are growing in size. Just to give a comparison, look at Walmart. Walmart is as big as an European country called Austria, as far as their GDP is concerned. Gross domestic production is equivalent to country's production. Forget about Walmart. Take Apple. Apple is almost equal to Indian GDP. So the production of Apple is as much as the production of whole of India. And India is not a small country. And India is not a small a country which can be ignored. It is one of the economic power. I think we stand fourth in the all over India, all over the world. And look at Apple. Apple is equal to us. Now just imagine the size of your opponent. Let us say I am going to have a negotiation with a transnational company. Do I have any chance of having anything to tell? And they will listen to me. So that's why the one side we are talking about transnational companies, multinational companies. And on the other side, we are talking about trade unions. Now, please don't be under the impression that trade unions are also small. Look at this International Trade Union Confederation. This is the logo of that confederation. It's a very oddly designed logo because they talk of simplistic design. So therefore, a lot of things are missing with this. But we have to make a meaning out of that. It's the world's largest trade union federation. 207 million workers, 207 billion workers are members of this confederation. Around 340 trade unions are the members. Confederation is a collection of trade unions all over the world. And it has its presence in 169 companies. See, when I talk about TNC, transnational company, it may have a presence in 10, 15 countries. But we are talking about a trade union which has presence in 169 countries. So that is what you should understand, that when we talk about collective bargaining, we are talking about a bargaining between huge parties who wield huge powers, who exercise influence, extreme influence over others. And when I say influence can be of any type. That also I'm going to talk about what kind of influences these huge entities can exert on others. So if you take an example of a small factory and there is a dispute in that small factory and they want to go for negotiation, and how the negotiation works between the two. First, there is a show of strength. Who is stronger? Who is vulnerable? So timings are very, very important. So does these things worry you? First, is the trade union fighting a losing battle? But looking at the confederation, it looks like that they are strong enough to protect themselves. But I'll just, you keep that opinion in your mind, then we will continue. Our trade unions are big enough to fight the battle with corporates because corporations are growing in size. But are the trade unions growing in the same mode? That's again another worrying factor. Are trade unions suitable only in democratic countries? Now, this is an interesting question. I'm very much interested in knowing that how we can ensure that the trade unions in dictators' country, trade unions where the dictators run the whole country, whether the trade unions can work there, or it can work only in democratic countries. That is something that you need to think and understand. If you have an answer, you can share with me. But if you are still confused what it is, then I leave you with that confusion, because these are the questions you have to find an answer by yourself. How democratic countries suitable for functioning of the trade union? That's an interesting thing that you need to understand. So I spoke about huge entities, the two entities that exist. They're really, really big entities. Now, how they show their or how they improve their strength so that they have a higher bargaining power on a negotiation table. Now they have various strategies. Now, how corporations influence on a democratic setup? It's a very interesting thing. You should understand financial power. See, financial power is a very important power in a democracy. You think of election bonds. So election bond is nothing but corporations showing their presence, their influence on the outcome of the elections. That is election bonds. The moment because again, look at the tax laws. The tax laws say that if you contribute for election funding and other thing, you get tax exemptions. Forget about tax exemptions. Your name would be kept secret. All of these laws were made to show that financial power really works in a democratic country. Whether it is illegal, the answer is no, because financial contribution to a political party is not an illegal act. Nothing wrong in that. But imagine a company which invests a lot of money in a political party. The political party has to pay back when it comes into power. So that's how they influence democracy. Next, policy capture. The policy capture is the moment a party gets elected on the financial power of a corporation. The corporation is going to influence the policy of the state. The policy of the state regarding labor jurisprudence. I'll give you a small example. Kerala was actually in 70s till 90s was considered to be a very strong trade union state, and it had a real strong trade union state. And the trade unions, they turned themselves into militant trade unions. And there was a system called as, I can't pronounce it in Malayalam, but actually the system is that if you bring mechanization, means if you bring machines and the machines do all the work, still you have to pay to the workers who are not doing anything. Without doing anything, they will be paid because they have that kind of influence exerted by the trade unions on the state because of trade unions' influence. As the influence shifted to the corporations, now those all things became redundant, null and void. So now in South, in Kerala, such rules are prohibited and made illegal, and many trade union leaders were arrested. Why there is a shift? This is because policy making has been captured by the corporations. Global reach. Now, this is the most important thing about corporations. Do you have any time you have seen any of the prime minister going for a foreign tour with a trade union leader? No, they go with an industrialist. Industrialists accompany them because they invest money in other countries. Every Indian's dream is to have their own multinational companies, and now we have our own multinational companies where we function in Europe, in South America, in Africa, where our companies have made investments. But money can move from one country to another country easily, but not labor. Workman cannot. For a workman to move from one country to another country, he has to have a passport, he has to have visa, he has to have show many of the documentations, and then only he can move from one country to another country. But can you invest in stock market of US? Yes. Sitting here, open your laptop, you invest. Capital moves easily, but not labor. That's why corporations have much better global reach as compared to others. they can influence the global movements through their easy moving money from one country to another country. That's why we say capital move from one country to another country easily, but not the labor. Media and narrative control is another most important influence which corporations have. They control the narratives that comes up in the news and other things. And that's the reason many a times that the real news, it doesn't reach the people because they control the narrative. Now, when I was in the college, there was a merger between Brook Bond and Lipton. I hope I'm right with the names of the companies. They merged. When these two companies merged, the news is on the front page. On an additional page for the newspaper, on that they had written the 10 benefits of a coffee. Every day if you drink coffee, the 10 benefits. Now, how 10 benefits of coffee is connected with merger of the two large companies? They are building a narrative towards it. See, when we talk about anything now, the moment any industry invests money, they talk benefits of that activity. Take even ethanol. Ethanol, there is so much of things happening about ethanol. First, they started. I hope you all know about ethanol is a product which is mixed with petrol for petrol cars. First, we called it as E20. So ethanol 20. Now there came ethanol 40, ethanol 60, ethanol 80. Now E100. Now E100 is the one. Now, and everybody talks about benefits of ethanol because our foreign reserves will improve and our foreign exchange will improve because we dependent on foreign oil would reduce. Yes, everything is correct. Everything is nice. Don't you think it's a narrative built by someone? Where is the opposite view? Where is the other view? There has to be other view, no? But other views are not brought to our notice. That is media and narrative control. This is how the corporations influence democracy. And when they influence democracy like this, they exercise a better negotiation power on a negotiation table. So that's why, as citizens, we need to understand how the narrative is slowly built brick by brick, and they make it into a nice a story around. Now, how trade unions influence democracy? First of all, mass membership. If corporations have money power, these people have people's power. Sheer number is there with them. With money, they have to invest and convert that money into votes. But trade union has members, as the members who are going to vote in the directions or under the instruction of their leaders. That is one very important power which trade unions enjoy: mass membership. That's why they need to maintain those membership. They need to maintain higher membership. So that is what is expected from them. So then next is about how to improve the membership. So that's why what they did is they opened up the membership for the non-workers also. So non-workmen can also become a member, because the moment the number increases, they exercise more control over the political parties. The next one is collective action. Now, collective action is very, very important. So here, I think next one is also similar to this. Solidarity is something that you should exhibit. Otherwise, trade unions cannot survive. Solidarity. When we talk about excessive use of force by government, we say that yes, excessive force was used, but it happened in the corner of a Karnataka. We are not concerned about it. It won't happen here. But please understand one thing: If you don't show solidarity to the person who is suffering because of the excessive force, he will not show the same solidarity when the excessive force is used against us or against you. Collective action is whether my interest is involved or not. I should fight for betterment of fellow people. So in Goa, we have our own association of teachers. And all the members of the association are full-time teachers appointed by the government of Goa. One day, a proposal came in the meeting that contract teachers and lecture basis teachers, their payment should be increased. So one person said, no, how we are interested in that? We are our regular faculty. We should not take up this matter. But that time, my chairman, the leader of our association, took trouble to convince everyone that if you protect the interest of our fellow teachers, we become more stronger, because when our issues come up, they stand by us. So that's how we made a representation to government of Goa, increased their per lecture salary payment and other. So collective action is the backbone of a trade union. So therefore, trade union expresses its opinion on all the matters connected with the society, because they have to remain relevant. They need to collect the support from all the people. Policy advocacy is another area where they influence the democracy, because they can really bring change by advocating for their rights and liabilities. See, what corporations do is a policy catch, but these fellows advocate it because they don't have money power. What they can do is they can use their influence as a political influence because of the number and advocate for that. Democratic training ground. Now, this is the most important power of a trade union, because whoever is a trade union leader will not remain a trade union leader. They will grow in the stature, and then they become ministers. They hold a very high post in Indian democracy. Now take the example of Justice Krishna Iyer. Justice Krishna Iyer was a trade union leader. Then he became MLA. Then he became a minister. Then he became judge of a high court. Then the judge of a Supreme Court. But where is his schooling is done? Schooling happened in a trade union. His basic ground training happened in a trade union. Take the example of George Fernandez. He was a defense minister of India, but he grew from a trade union. From Mangalore, he grew up to that level. Jawaharlal Nehru was very closely connected with trade union. Even Subhash Chandra Bose was very closely connected with the trade union. So therefore, how trade union exercises its influence from outside because of the sheer number, through inside because their leaders have a potential to become. I forgot to mention V.V. Giri, the Vice President of India. V.V. Giri was a great trade union leader. So therefore, but have observed one thing. All the examples which I quoted are the examples from early 70s, early 80s, 90s. All these leaders were existing during that time. Now, do you see any trade union leader reaching to that pinnacle? It is becoming rarer and rarer. That's again a worrying point. That's a real worrying point. Because similarly, during the independence, most of the ministers and MLAs were advocates. Now, number has come down drastically. Big drop is there in their numbers. That's again a worrying point. So these are all the indications that the democracy is changing in India, and change is not always good. As long as change is for the better, we must appreciate it. But I do see a lot of problem in this development. Why trade union leaders are not reaching to that level what they used to do in the 90s, in the 1960s, 70s, 80s, 90s. Now it's not happening. So therefore, when I ask the question whether the trade union is losing the battle, it looks like they are finding it difficult to stay afloat. So this is something you have to keep in mind, because collective bargaining is all connected with your power to bargain. Now, example of a corporation lobby, how corporation lobby work. Now look at this. In US, Google, Meta, Apple, Microsoft, these all grew in size, grew very fast. And the most important thing is that they held data of the whole nation. All the people living in US, all over the world, their personal data was with them. As they were growing in size, they started controlling the market, and which is not correct. Market should not go into one person's hand. There should be equal playing field for all. So therefore, the US Congress decided to bring a law in controlling the growth of these huge entities, and cut them to proper size so that market can give equal competition. But corporations had grown so big that Congress found it very difficult to make an antitrust laws. Antitrust law means a law which is going to bring equal competition in the market. They call it as antitrust. We call it as competition laws. So they could not bring strong, strict competition laws. Everything became a problematic because of their sheer size and also with their sheer influence. Forget about competition in the market. They could not even bring stricter taxation laws. And even India has lost many taxation cases against Vodafone. They lost against various other multinational companies. And that's why now government of India is dead against arbitration. And the governments are adding that clause in the contract that the dispute will not go for arbitration, because they say arbitration is an attack on their sovereignty. Why I should be bound by the decision of a third party? Ours is a sovereign country. We have our own judiciary. If you have faith in our judiciary, you invest in it. So that's the takeaway from the present Indian government. Look at this second set of companies. They are highly polluting industries. Forest fires, drought, cyclones, increased number of cyclones, increased vigor of the cyclones. These all are result of a climate change. But whether climate change is being handled effectively, the answer is again no. Because if you bring climate change discussion on the international forum, America doesn't sign it. Why America is not signing it? Because it is under the control and influence of capitalists. So energy corporations like ExxonMobil, British Petroleum, Armaco, now these all are the countries using their power to keep climate legislations which are less stricter. And also they make sure that the third world countries, underdeveloped countries, don't adopt stricter legislation so that they can go there and pollute those countries. Pharmaceutical sectors. Now imagine the most strictest law that is there in any of the legal system is IPR. Why IPR is so strict? Why patents are so well implemented? And you know, if you look at any of the assessing agencies, if you take NAC or you take NIRF, you take anything, there they talk about how many activities are done on IPR. Now, all this focus on IPR is because that is how the companies are going to make more profit. Pharmaceutical sectors have made sure that the patents are protected. Price controls are there in their hands. Even though they are all life-saving drugs, but still they do the price control. And you know, the corporations work so well. In the last 1 decade, the investment on research and development of anti-balding medicines. Now, anti-balding medicines means against the hair loss is 90%, 90 times more than investment on life-saving drugs for tropical diseases. Tropical diseases are diseases where heavy rain and high temperature exist. The tropical diseases like malaria and other things. There, the investment is only 10% and anti-balding, fair skin, these 90 times more investment are being done in the world. Why they are investing there and not in life-saving drugs? This is all because capitalists control the policies. Look at the next one is India. Let us take the Indian example. In India, from 100 to 300, the labor code, industrial relations code are going to be applied. Is the threshold is increased from 100 to 300. Is it a result of lobby? Possible, very high possibility. I don't have any evidence to show, but you cannot deny the possibilities. United States right to work laws. A union can survive if they have financial support. And most of the financial support comes from the membership fees. And trade union lobbied for that payment of wages act. So under payment of wages, you have to pay wages on a regular intervals. And you are permitted to do certain deductions from the salary. And beyond that, you cannot do the deductions. Trade union wanted to add a membership fee as one of the deduction. So it goes like this. On the first of the month, when my salary comes, my membership fee would be deducted by the employer, deposited with the trade union account. I get the remaining. That is what arrangement which trade union wanted. But in the United States, it became too difficult to manage. Now, this is the latest problem relating to labor jurisprudence, that is a gig economy corporations. Now, gig economy is they refuse to call them as employees. Take Swiggy, Zomato, Blinkit. Take anyone. They are not employees. They are partners. They call it executive partners. Some fancy name is given to them. And being a partner, they cannot expect bonus, gratuity. They cannot expect traveling allowance, DNS allowance, all the benefits that an employee enjoys. None of them are available to them. And many people wanted to protect the interest of the gig workers. But hardly, only Karnataka has passed a Gig Workers Act. But whereas other states have not done any of those things. And they are still vulnerable. The gig workers are vulnerable. Please understand one thing. Gig workers, they work on a regular employment. In the spare time, they do this job. Fine, agreed. If you put a burden on the employer that you pay bonus, you pay gratuity, you give them a leave, paid leave if you give them, then the cost will go up. And then this system of the gig economy will collapse. I completely agree. But how about making a law that a gig worker who drives on a busy road at a high speed so that the customer remains happy, can't he be properly insured? Can't his vehicle be insured? Can't his health be insured? So you bring in the concept of insurance. Don't spend money. Make the payment through this, what you call bulk payment for the bulk insurance. See, you can do it if you put your mind and heart into that. And gig economy is not a new concept for India. You take the example of Bollywood. In the Bollywood, junior artists are there, stuntmen are there, light boys are there. Then we have songwriters, musicians. They all work on invitation. So you invite them, they come, they perform, they get paid and they go. So they are not employed anywhere. So that is what you have to keep in mind. They are never employed. So that's why the gig economy, there is no law anywhere. Even European Union is struggling to pass a strong law protecting the these gig economy workers, but not done as of now. Labor market deregulation. Now, golden handshake is the heart of labor jurisprudence. So when the employer finds it difficult to keep the workers and worker finds it difficult to stay and continue to work, they have a golden handshake. They shake hands and they go apart. And why this handshake is golden in nature? Because there is an exchange of values. So during my college days, computerization was introduced into banking sector and insurance sector. Trade unions built a public opinion against it, but they could not succeed. And that from that time onwards, I am of the strong opinion that you cannot stop a technology. Technology will definitely come. How much you fight against it, you may delay it, but you cannot deny it. And that time, a concept of VRS was introduced, voluntary retirement scheme was introduced, because most of the workers in their late 50s could not adapt to computerized working style. So therefore, they had to move out of employment. And that time they brought a scheme where they were paid some amount for the retirement benefits so that they can lead a retired life fairly well. And they were said they are given goodbye with a golden handshake. But in Latin America, dismissal procedures was eased out and it was made it easy. But the severance pay, that is the payment at the time of resignation, was reduced drastically. These are the impact of labor laws. But don't worry, it's not corporations which are very strong all the time. Trade unions also have done miracles. Now look at this poster: 8 hours labor, 8 hours recreation, 8 hours rest. Now this was the slogan in the late 19th and early 20th century, when people were made to work 16 hours, 18 hours a day. And successfully they brought 8 hours and work days, and also 1 day in a week holiday. All these things were there. Many of us are of a strong opinion that West has influenced our culture. I agree, West has influenced our culture. But one influence which we all should be proud of is the influence on labor jurisprudence. Whatever rights Indian workers are enjoying, we have not fought for it. All Western workers have fought for it and they have achieved it. And based on that, they could give the benefit of that. India being a colony of UK, so therefore all the benefits were transferred to India. And this is a success of a trade union because they could achieve this. And the solidarity movement in 1980s. Now this is a movement which we should all be proud of, because one trade union toppled the whole government. Because in Poland there was a communist influence was there, USSR influence was there on Poland in 1980s, and one trade union took over, run by an electrician as their leader. They took the party head on. They toppled the whole government. And they could manage it because of the sheer strength they had, the number that was there with them. Take in the Indian example. Now, NREGA, that is a National Rural Employment Guarantee Act. Now they have re-christianed it. They have given a new name for that. That is Vikasit Bharat, some guarantee, Ramji, that they call it as VBG Ramji. That is the creation of All India Kisan Sabha. It's a confederation of trade unions. They came together and they said that the rural employment guarantee scheme should be passed. So they have played a very important role in passing this. And then we have this MKSS, Mazdoor Kisan Shakti Sangatana. This is not actually a trade union because it is not registered under Trade Unions Act, but it is a collection of workers run by Medha Patkar and others. And they brought Right to Information Act. So they could achieve this Dr. Boregoda is asking why collective bargaining is not as popular in India as it is in Western countries. I should say that it is popular. Please take it from my words. But what is happening here is most of the time, whenever there is a labor dispute, it is never a collective bargaining between two parties. State takes an active interest. So it becomes a tripartite bargain between the parties. So therefore, bargaining do happen in India also, but it is always tripartite because state takes active interest in the outcome. And RTI, Right to Information Act, is the contribution of this MKSS, Mazdoor Kisan Shakti Sangathan. So what I'm trying to establish here is corporations are very strong, but trade unions can give a good fight when it comes to collective bargaining. So that you have to keep in mind. Here one more question is there. Sir, as per our understanding, leaders of the trade union join hands with the employer for their greed. In such situation, how can we expect protection of rights of workers? Hand in glove. Yeah, it's a very, very good and important as well as difficult question that has been put to me. See, what I feel is employer and trade union leaders going hand in glove is a high possibility. Absolutely correct. But at the same time, when we come up with a collective bargaining, when you come up with an agreement, and we come up with a settlement, the settlement has a certain degree of what you call it as protection. So if the settlement is out of the greed between or hand in glove between the employer and the workman, the settlement can very well be challenged in the court and it can be set aside. See, we run the risk. We run because human nature we cannot control. Greed is a part of the human nature. So therefore, we have to be very much alert against that greed. So that's why what should we do is we should build in checks and balances within the system. So when what I mean by checks and balances, what I mean is one person will not decide everything. It has to be decided by multi-level approval system. When you have multi-level approval system, they can buy 10 people, but 11th fellow would raise an objection. When one person raises an objection, the remaining 10 needs to justify that decision. So that's why we need to build that checks and balances in the system. Definitely it will delay the decision making. If one person is deciding, we can decide in a minute. When you have 11 people involved in the decision making, it may take a day or two, or maybe a week. But that delay is justifiable because you will survive because of the checks and balances. So now, I think few more things have come. See, gig and platform workers can exercise their collective bargaining because they have to form an association. Now, please understand one thing. When I say association, you need not register it under Trade Unions Act. You can register it under Cooperative Societies Act. You can register it under Trust Act. So there are various other places out there where you can register. And you can register it on Trade Unions Act itself. But you are not connected with any one industry, but you are connected with all the workers. So once you all come together, you can exercise your collective bargaining rights. Please understand, before exercising your collective bargaining rights, you have to show your strength. Strength can be shown by disruption. Now, disruption means, so let us say we declare strike on, say, 11 o'clock in the night. Next day morning, Blinkit orders start pouring in. We don't go to deliver them. Panic sets in. People starts writing in the social media and other. It will succeed only if Blinkit as well as other subsidiary people who are providing the similar service all strike the work at a time. Then the impact is more. If you could not bring all of them together, then your attempt to show strength will fail. So that is what is required. Allowing multiple registered unions within a single enterprise often leads to inter-union rivalry, weakening the bargaining leverage and fractured negotiation. See, here I will answer this question, Vijay. You give me time. I'll definitely answer this question. And Industrial Relation Code, a provision to control the multi-union situation, there is, but please understand, it is not strong enough to give all the power to one trade union. I'll come to that attempt made by the labor control IR code in providing that strength. So what do you feel about it? Which of the parties, corporations or trade unions, enjoy public support? So when we talk about public support, who enjoys more public support? Is it trade unions or is it corporations? Again, understand how the narrative built in the minds of the people in a public forum is important. So Tata Namak, Desh Ka Namak. Can anyone go against the Tata? Because Tata enjoys so much of good image among the people that it's very difficult to go against Tata's. I think there was one more slogan, some Dhadkan, Hindustan ki Dhadkan, that hero ka Dhadkan, Hindustan ki Dhadkan, something. See, they all are capturing the imagination of the people. So therefore, going against corporations becomes difficult. But trade union enjoys traditional support from the society. No matter what corporations do, they take one step, we all fall on the protecting the trade unions. Is the survival of trade unions important for democracy? Answer is yes. To survive democracy, it is important. Now, reality of collective bargaining. I'll take you through the reality now. See, this is how the whole collective bargaining works. United, we stand. Divided, we fall. These are the cousins of the same statement. United, we bargain. Divided, we beg. An injury to one is an injury to all. So this is why I told about solidarity. We have to show solidarity to others' needs and requirements. As a show of support, we have to go on a strike. We have to show our support. Power in unity, strength in solidarity. Workers of the world unite. Now that's a statement. So united we stand, divided we fall is the historically very important slogan. So how collective bargaining works and what is collective bargaining? I've not read through this whole thing. Because basically, there are two parties. One is employer, other one is the workman or the association of workmen. They come together, they discuss. What they discuss? One, they discuss terms and conditions of employment. They discuss the regulating the relationship between the employer and the workers. They discuss regulating the relationship between their organization and employer's organization. So when they discuss these things, it becomes a collective bargaining. So when I talk about conditions and terms of employment, I'm talking about safety, wages, rest, and other amenities that should be provided to the workers. All these things form part of the collective bargaining. The bargaining power of trade unions, let us come to the law. Okay, trade union's bargaining power, is it protected by the law? That's the question. I'm going to answer one by one. First, whether the law support density of membership. I think one of our participant had asked this question. Multi-union, there is a provision against multi-unionism. So there were, Dr. Vidya is asking, sir, industrial relation code speaks about negotiating union and employer will have to recognize the negotiating union council. Yes, I'll come to that, Dr. Vidya. I'll definitely reach there. Jay Kumar is talking about what are the important big challenges faced in collective bargaining in the present scenario, especially under the new labor code. Definitely, I'll touch upon both of them. So now, whether the law support density of membership. Now, density means more membership, more power you have. Lesser the membership or distributed membership, you will have lesser power. So look at this. Law of recognition. It is part of Trade Unions Act. Now it's a part of Industrial Relations Code. Law of recognition actually diverts all the members into under one trade union. Now, law of recognition is about if I, as an employer, recognize if I recognize one. So if I recognize one trade union, then people will start joining them. The advantage of recognition is like Dr. Vidya was asking about negotiating union and negotiating council. Similarly, law of recognition is also part of that, because once you recognize a trade union as an employer, he has to negotiate with that trade union only. So I am a trade union, but not recognized. I have a demand. I have to go to that trade union, which is recognized, request that recognized trade union to raise the issue with the others. So that is what recognized trade union is. And that ensures density of membership. Second, civil immunity. This immunity is about against the virus and bacteria, but take that green things as litigations. So civil immunity is basically protect trade union members against breach of contract, against acts which are restraint of trade, because all these things can attract civil cases, and you may have to shell out huge compensations. If I, as an individual, breach the contract, I have to pay compensation. But if I, as a member of a trade union, breach the contract, I need not pay. Which contract I'm talking about? Contract of employment. If you go on a strike, you are basically breaking the contract of employment. But still, you cannot be prosecuted. Still, there cannot be a case against you because of the protection given against for the civil immunity. Criminal liability. See, the moment we come together and decide to cause financial damage to the employer, it's nothing but conspiracy. But criminal conspiracy protection is given against the trade unions. That again ensures density of membership. This is negotiating union and negotiating council. See, this negotiating union and council, if employer recognizes them, see, again, please understand one thing. What is negotiating council? Negotiating council is collection of all trade unions, and we pick up representative from all the trade unions and make it into a negotiating council, and they come and discuss with us. It is counterproductive when it comes to the strength of the trade union, because it will distribute the membership among all, which is not good, which is not correct. So please understand one thing, negotiating union is a very important provision, but whereas negotiating council is not so. The law should encourage concentration of membership with one union. If the membership gets distributed, the unions cannot have the desired strength to negotiate. So that is the worrying factor. Now, political and social environment which they need to possess. When it comes to political alliances, definitely all the trade unions are associated with one or the other political parties. We have INTUC, we have ITUC, we have C2, and we have BMS, Bharatiya Mazdoor Sabha. Then we have All India Trade Union Confederation, Indian National Trade Union Congress. So all these are associated with Congress, Communist Party, Bharatiya Janata Party. Political alliance does exist, and that is what is going to give them the strength. As I said, the corporations hold the power to give narratives, but narrative framing by the trade union is also very important. When they fight for their right, it's very important how they term it. See, if you call a fight for livelihood, right of livelihood, you can get support from anyone. But instead of livelihood, if you term it as a fight for securing the right of entertainment, nobody will support you. Because see, when people are dying of starvation, you want entertainment, what kind of fight is this? But if you call it as livelihood, definitely they will support. So the narrative framing is very important. Media outreach. Now see, now we are in a threshold. Now there's again the question is about the modern era, industrial relation code and modern era. So media outreach has become very complex now. Initially, when social media became popular, everybody said that the print media and electronic media could be purchased. And now social media cannot be purchased because it is not run by one person. So therefore, now truth will prevail everywhere. That was the understanding. But after a few years, now what is our understanding? Still, media can be influenced. Narrative can be built. That Alia Bhatt went to Cannes Film Festival, everybody said that she cut a very sorry figure there. Now, slowly we are coming to know that it was a hate campaign against her. Now, how could you make a hate campaign? Catch hold of 10 influencers and they have millions of followers. Ask them to make a video the way you want and put it and pay the influencer. It has become much cheaper to influence media now. But earlier, print media and electronic media, they need to shell out huge money. And now it has become much cheaper. Coalition building, that is through solidarity actions, you can build a coalition of other people showing the interest in this. Escalation ladder, this is very, very important. When you fight for your right, you have to fight from bottom to top. So you make an application, you send a notice, then you go up, slowly you climb the ladder. Otherwise, you directly jump to the final step. Then people don't agree with that. Transparent communication. Now, this is again a very interesting one because you have to keep people together and people's faith with you, support with you. So therefore, your communication should be transparent. And if you converse with the leaders of the opposite party, then you have to come and reveal what was discussed. Follow lawful procedures. All the procedures respect statutory framework. So this is how you build political and social environment for your betterment. Trade union, okay, I'll just skip this because I'm running out of time. Now, mechanisms similar to collective bargaining is works committee. This is similar to trade union functioning and collective bargaining. It is 100 or more workers employed. Works committee has to be formed. There is a representative of employer and workers. But please understand one thing. This works committee concept has not been very successful. And it is because of non-cooperation from a trade union. Because works committee, if it works better, trade union loses its relevance. Because their problems, now look at the duty of the works committee. Last point in the slide. promote, secure good relations, common interest, material differences should be removed. But this is what trade union also do. And if the whole thing is done by the works committee, then trade union lose its relevance. So that's why this works committee is a failure. Grievance redress committee, it's again interferes with the trade unions functioning. 20 or more workers will have grievance redressal committee. Individual grievances are covered under this. Equal number of members from the employer and workers are kept. Now, these are all about composition. But what is important here is its interference with the trade union activity. But look at the decision on an application. Majority out of 10 workers, if 10 members, if I agree, then it is approved. But look at the second condition. 50% of the workers should have agreed for it. So there are two conditions for the valid approval of application. One is 50% of the workers should agree and minimum 50% of the total members should agree. So therefore, that is how it is done. Now, conciliation is similar to collective bargaining, but here there is a third party involved with that. Now I'm taking you to effect of Mediation Act on 2020, Mediation Act of 2023 on the Labor Code. Section 55 says, subject to the enactment mentioned in the second schedule, the Act has an overriding effect. And if you go to the second schedule of Mediation Act 2023, Industrial Disputes Act 1947 is mentioned, and Industrial Relations Code 2023 is also mentioned. Both are mentioned, first and the last. And look at the language of the section 55. It says this act shall have overriding effect for conduct of mediation or conciliation under any other law. Overriding effect. But how do you interpret subject to the enactments mentioned in the second schedule? Now, if you take the first line, subject to the enactment mentioned in the second schedule, means the acts mentioned in the second schedule are beyond the application of section 55. So therefore, the collective bargaining, conciliation proceedings under the Industrial Relation Code continues to apply. It is applicable. But all other legislations which prescribe negotiation and mediation, there the Mediation Act 2023 will prevail. Again, I'll tell you why I come up with this interpretation is because when you settle a dispute under Industrial Relation Code, the copy of the settlement should go to appropriate government also, because appropriate government is equally interested party in this whole dispute resolution process. And appropriate government will look into the impact of the settlement on the economy of the nation. So that's why the Mediation Act 2023 is not applicable to Labor Code. So Labor Code, or what we say Industrial Relation Code, will continue to operate. And these 27 is enforcement of a settlement agreement is not applicable to the settlement of collective bargaining under the Industrial Relations Code. Now, this is the last slide where I'm talking about why collective bargaining is in decline. So that was also expressed by one of the participants, that why there is not much collective bargaining happening in India. First reason why it is declining, why it will not survive for a very long time: global capital mobility, local labor immobility. So capital moves globally, labor moves locally. And that's the reason why corporations are becoming more and more stronger. I said in the beginning of the lecture that we have an International Trade Union Confederation which has presence in 160 countries. But can that trade union can strike the work all over the world and bring the world to standstill? No. Because the fragmentation has happened. So the distribution of the membership is so wide and so thin that in a country there may be 100 who would be going for a strike, but there will be millions who would be going to work. Another problem is the fragmentation of work. When the work gets fragmented, now we have concept of outsourcing. When we outsource the work, we create outsourcing. That also becomes an issue, and it's very difficult to create a financial pressure on the employer. Decline in union density, that's another major problem. Memberships are dwindling, so therefore collective bargaining is declining. Rise of corporate power, that is true, that's a reality. There are two things which are rising in the world. One is the democracy, another one is the corporate power. And it looks like both coexist together. Wherever democracy is stronger, corporate power will increase. There are a few more questions are there. Is collective bargaining is satisfied gender equality, mostly for female workers? So here, gender equality is seen in the grievance redressal committee, what was mentioned there. There they are saying that if 20% of the workforce is a female, then the grievance committee should have 20% female members. Proportionally, they should be mentioned there. When we talk about gender equality, when it comes to trade union leadership, now presently there are very important female leaders are there at national level. When it comes to workers' rights, they are fighting very hard. Then female workers' rights, when it comes to their work, they mostly fall under unorganized sector, like domestic help or Anganwadi workers. Though when they are in unorganized sector, protecting their rights becomes difficult. Organized sector, male are dominating, female are very less. Thank you very much, Jai Kumar sir. And is work from home impacts trade union by weakening traditional workplace solidarity? Definitely, Dr. Vijay. What happens is trade union strength, as you mentioned, lies in solidarity. It is fraternity feeling, brotherhood feeling. If that cannot happen if they are working from home. So that will definitely impact them. So this is what I had a few discussions to make, and now I open for questions. Anyway, questions were asked continuously. You may ask now. And I thank you for the opportunity given by Vivekananda Law College. Thank you very much.
Thank you, sir, for your valuable insight about collective bargaining under new labor codes. Why dialogue is a necessity. Dear participants, the session is open for discussion. If you have any questions, any clarification, you can directly ask the resource person.
Thank you very much, because you have raised quite a few questions, and they were very, very inquisitive questions. Actually, leg spin, off spin, all the questions came. And thank you very much for keeping me on the toes.
Yes, sir. Thank you.
Thank you, sir.
May I now request Sri Sadashiva MS, Assistant Professor, Vivekananda College of Law, Bangalore, to propose vote of thanks.
Good evening to all. Myself, Sadashiva, Assistant Professor. It's my proud privilege to extend vote of thanks on this occasion. Firstly, I would like to thank today's speaker, Dr. Babugoda Patil sir, Associate Professor, VM Salagankor Law College, Goa, for sharing his experience and expertise on the topic collective bargaining under the labor code. Why dialogue is a necessity. Sir, I, on behalf of Janata Education Society's Vivekananda College of Law, extend my heartfelt thanks for sparing your valuable time with us. I thank our beloved principal, Professor Dr. K.B. Kempegoda sir, for constant support and guidance in organizing this webinar. Thank you, sir. We extend our heartfelt gratitude to our management for their support and cooperation. I also thank our IQAC coordinator, Dr. Bhuvneshwari SK, for meticulously organizing this program. Thank you, ma'am. I extend my sincere thanks to Dr. Vijay A.M., Assistant Professor and Faculty Coordinator for smooth conducting of this webinar. Thank you, sir. We place on record our appreciation for active participation of participants across the country. Thank you all for your cooperation and support. I also express my gratitude to our esteemed colleagues for constant support and guidance in organizing this webinar. Thank you all.
Thank you, sir. Thank you.
Thank you, sir. Dear participant, we are pleased to inform you that the session scheduled day after tomorrow, that is on 29th Monday, will be delivered by Professor Sandeep Desai, Associate Professor, MET Law School, Bangalore, who will be discussing on prophecies and fallacies of the labor codes. Looking forward to see you all day after tomorrow at the same time. Thank you, one and all.
Thank you, sir. Thank you.
Thank you, sir. Thank you so much.
Thank you, sir. Thank you, Patil, sir.
Thank you, sir.
Thank you,
Thank you.
sir.
Thank you
Thank
very
you so
much.
Bye, sir. Bye.
It is indeed a nice presentation. Thank you very much.
Sir,
Highly
thank you,
educative
sir.
also.
Thank you.
Bye, sir. Thank you.
Bye.
Thank you.
Thank you.
Thank you, sir. Thank you.
Should I end the session, sir?
Yes, madam.
Yes, madam.